Harrington here, folks, coming back at you. All right, I'm out of uniform today, but it's Casual Friday, so try not to judge me too harshly. Now, here's what I'd like to do today. We're going to talk about litigation. And before you wrinkle up your nose and say, Jeff, why are you trying to make me eat my vegetables? All right, well, look, you are small business owners and real estate investors, okay? As small business owners, you're fighting with your clients, your suppliers, your landlord, your employee, etc. If you're a real estate investor, you're fighting with, well, contractors, associations, buyers sometimes, maybe a realtor here and there. You get the idea. It's fight, fight, fight. And you foreigners are thinking, Americans go running to the courthouse like they're giving out candy. And there might be something to that. But it is probably better than the alternative, right? Frontier justice. And for the most part, our courthouses do work. You can get something done. Unless you're in Miami. Those people aren't here. And whenever you guys come to my office and we're talking about a dispute that is brewing or that you're in, you always have the same question for me, don't you? We could probably say it together. How much is this going to cost me? Well, look, you're asking the right question. Of course, that's how you do the analysis. You got to decide whether this is a lawsuit worth getting involved in or not. So it is the right question. And of course, the only honest answer is, who the hell knows? I mean, the questions are these. Well, which court are we in? Is this a matter that's going to settle along the way? Can it be resolved as summary judgment? Are we going to have to go to trial? What are the chances of appeal? See what I mean? Nobody really knows. But I do realize that that is an entirely unsatisfactory answer to you and doesn't help you at all in making your decision. So, you know what? I should be able to give you a better answer than that. But it's not a simple answer. And I'm going to try not to overwhelm you. This is not AMSR. I'm not trying to put you to sleep. So this is what I'm going to do. I'm going to break it into 3 stages. We're going to talk about the initial stages, then we're going to talk about the judgment phase, and then we're going to talk about post-judgment phase. And I'm going to do that as 3 separate videos. So this is going to be a series, a litigation series, so I can give it to you in bite-sized, digestible pieces. Now here's the kicker. Here's the strategy. I'm going to get you into each stage of a lawsuit and give you the best idea I can about what expenses you can expect at each stage and what are the factors that drive those costs up or down. Spoiler alert, usually up. So come with me on this ride. I understand it's not the most sexy topic, but it is oh so very useful. And if we're not careful, we may even have a little fun along the way. So here we go. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1, the complaint. All right, so this is the first of a 3-part series of videos, and I'm going to be giving this to you from the plaintiff's point of view. It doesn't really make any difference, if you're the defendant or the plaintiff, the process is the same. And I'm going to be talking from the point of view of a state court case, not a federal court case. There can be some differences. Now, as I promised, I'm going to give you some actual dollar figures, which most attorneys are terrified to do. But obviously, all the caveats apply. I guess the nice thing is this, and one of the purposes of these videos is that by the time we're done, I think you're going to understand why it is that no attorney can ever really tell you how much this is going to cost. All right, so let's get into it. Preparation of the complaint. All right, first of all, I'm going to meet with you guys. You're going to tell me the story, and I love you. I'm on your side. I believe you, but let me get into the evidence because you've heard the expression, every story has 3 sides. Yeah, okay, forget about all that. In litigation, there's really only one truth, and that's the truth that you can prove with evidence. So let me get into the case a little bit. Me and my team, we're going to look at your docs, we're going to look at your pictures and any videos you have. We're going to think about what kind of affidavits maybe you can sign and what kind of testimony you could give if we get to trial. Ideally, we're not going to lean too heavily on your testimony because, we got to sell the judge or the jury with this story. And having documentary evidence is the best way to do that because otherwise it puts a lot of pressure on you, right? I mean, we don't want you freezing up or getting mad or crying unless it's for special effect. I have seen tears be mighty with a jury, I tell you. So that's what that part of the process looks like. We're going to get everything together. We're going to get our theory of the case and we're going to draft the complaint. All right, then you just got to file it. Well, typical filing fee is $400, but it does depend a bit because like these foreclosure actions, for example, they're much more expensive. They can be like $1,900 just for the filing fee. Then there's service of process, and that, of course, depends upon the number of defendants you have, but you can probably count on something like $60 to $100 per defendant. Put it all together and just ballpark, I'm going to say count on between $2,500 and $3,500, depending upon those factors we just discussed. And that's just to get the case off the ground. All right, but that's part 1. Part 2, this is what we call the pleadings stage. So if we're the plaintiff, what we're trying to do is get the defendant to file an answer so we can then move on with the case, get to summary judgment or trial. All right, but they may not make it that easy for us. Okay, instead of filing an answer, what they may do is file a motion to dismiss. A lot of times those motions to dismiss are highly technical. You may not even understand the arguments, and they can file multiple motions to dismiss. And there's some drawbacks to that. Let's just have a quick strategy session here. So when it comes to filing motions to dismiss, you do have a strategic decision to make, because when you file a motion to dismiss, it almost never ends the case. The judge is always going to give you leave to amend. So then the plaintiff will go back and rework the complaint and then file an amended complaint, or a second amended complaint, or a third amended complaint. You get the idea. But what happens is that if you file a bunch of motions to dismiss, you're actually teaching the plaintiff how to write a better complaint. So by the time you get to the second or third amended version, well, it's much better than it was originally. So as a defendant, you have a decision to make. Do you want to go through that whole process, or maybe you'll let them take their crappy complaint all the way to trial? Motion to dismiss is the most common motion you'll see at the pleading stage, but there are a few other things you might see. Motion to strike, motion for more definite statement, sham pleadings, etc. There are a few other things. So how do we put a price on this stage? You know, it could be zero. Maybe you file your complaint and they file their answer. Your costs are zero. Conversely, it could be, maybe you have to defend 5 of these motions, right? And that means you got to file the responses, you got to go to those hearings, and you got to amend your complaint. So all I can do here is give you my best estimate, and based on experience, I'm going to go with something like $1,500, right? Let's say that maybe there are going to be 2 motions to dismiss that you have to fight off, around $1,500, say $1,500 to $2,000, something like that maybe. So this is part 3. We're getting there, guys. Hang in there. So discovery. What is discovery? Well, that is your chance. Remember how the only truth in litigation is what you can prove? Okay, so let's find out what kind of evidence they have. And that's the purpose of discovery. So there are 3 different discovery products we can send out. We can ask for documents. We can send a list of questions that they have to answer under oath. There's something called admissions. We could try that. And then the big one, of course, is depositions. But let's break this down. The cheaper and easier thing to do is put together requests on paper. So we'll send off what's called interrogatories or a request to produce, and then we'll wait for them to respond. Okay, now, are they going to just respond, or are they going to give us a hard time? I'll tell you what, it's pretty common for them to give you a hard time. Let's take interrogatories, for example. So that's a list of questions that they are going to have to answer under oath. Well, they could just send back blanket objections, right? Just, I object to every single question. I'm not going to answer any of them. Now, can they get away with that? No, probably not, unless your questions are really poorly crafted, but probably not. They're going to have to answer, but you may have to file what's called a motion to compel. You may even have to go in front of a judge and say, Judge, make them answer. So that, of course, will make a difference in the cost of this stage. And then probably the heaviest hammer you have at this stage is what's called a deposition. And I need to deal with that separately because it's much more expensive. It's a bit of a, ordeal. You got to get together, the whole group. I mean, now we can do it by video, and that helps. But you're still going to have a court reporter there. You're probably going to take the better part of the day to get through the whole thing. So that's a totally different price point. Let me put it to you this way. The interrogatories or request to produce, the admissions, I mean, even if you have to file some motions to compel and go back and forth with opposing counsel, maybe you're looking at something like $3,500, $4,000 for that, that whole process, all that paperwork. A deposition could be that much, just one deposition of one defendant. So you see what I mean? So why might you even want to do a deposition? Well, nobody likes to be deposed. You could freak out the other side, and that could spur them to settle. Or here's another reason. Let's say you got an opposing counsel who does want to play a lot of games. He is going to object to everything. He's going to give you crappy responses to your discovery requests. And you know that there's going to be a lot of motion practice to eventually drag this stuff out of him or her. Well, maybe you just want to do a deposition because then they got nowhere to hide. They're sitting in a chair under oath. You get to just grill them. So, there's a gamesmanship there. There's strategic decisions to make. So let's put it this way. If we're talking about the discovery stage and what kind of expenses you can expect, I like the figure $3,500, ballpark. But for each deposition you want to do, add another $3,500. So that's as far as we're going to go today. I hope you guys don't feel too much like you're eating your vegetables here. And let me say just one thing. I have dealt with this topic before in writing and in previous videos, but this is still a good video to bring out right now because there have been some changes, some very important changes in the law here in Florida with regard to the courthouses. Specifically, the Florida Supreme Court has laid out a whole new paradigm that the courthouses and the judges are supposed to follow, and it makes these cases lightning fast. I gotta say, it's pretty impressive. In fact, if they're able to pull this off, so far Miami is not even getting anywhere near pulling this off, but the other courthouses that I've seen in the counties that I've seen, like Palm Beach, they're trying very hard to stick with these timelines that the Florida Supreme Court has imposed. Now, if these courthouses are actually able to stick with the timelines that the Florida Supreme Court has imposed, then I think Florida is going to become a go-to state for litigation. I mean, it's impressive. And it's good for many reasons, and here's one of them. You know, in litigation, I'm glad that we have the system that we have. It's probably the best in the world, even though it's imperfect. And one of the imperfections it has is that the party with more money has a distinct advantage. And one of the ways that they can deep pocket you is by dragging these cases out. They prolong it to the point that it's too expensive for the party that has less money. And they eventually end up throwing up their hands and they just move on with their lives, right? And that's not a good way to win a lawsuit, or it's not, it's not a fair way to win a lawsuit. So stick with me on this series. I think you're going to find it very useful. Recuerda que hablamos español, and I will see you guys next time.